Well, hello there, and welcome to the Employment Law Show. John Scholes and Lior Samfiru. We are back to fill your head full of useful knowledge. We are talking about your employment rights and all that stuff. So let's get right into it, shall we, Lior? All kinds of things to talk about today. What you need to know about medical leaves. This is very important stuff for a lot of people, and quite often for quite a lengthy time, too. So we'll get into that in just a bit as well. Pocket Employment Lawyer at pocketemploymentlawyer.ca. Details on that on the way as well. This is something very cool. You can check out in the meantime while we sit here and idly chat between the two of us, shall we? But first, my friend, week that was. What do you got for me today?
This actually was a really interesting week. A lot of people that saw the show very recently called me, and it triggered something in them. It raised questions, or they maybe realized, wait a second, I thought my problem is just something I had to live with. And they saw the show and they realized, well, maybe not. Maybe there is a solution. And guess what? There was a solution. And that is exactly what I'm here to preach, what I'm here to say. If you have a workplace problem, if your boss did something or said something, maybe it wasn't a good week, something happened in the workplace, or you got some bad news about your job, there's almost always something you can do about it to make your situation better. So that's what we're here to talk about on this show every single week. Or if you want to talk to me privately, if you want to talk about your specific situation and want to know whether what happened to you is right and what to do about it, call me. We'll give you my contact information or email. Happy to correspond, happy to chat. I do this every day, all day. So there's no bad questions. There's only answers. There's only solutions. But week there was a situation that came across my desk just over the past few days. I spoke with a gentleman that worked in a sales position. He was 100% commission. And, you know, one of the most sacred thing for salespeople that earn commission is you don't mess with their commission structure. You just don't, because that's their livelihood. Well, this particular employee or salesperson found himself in a situation where the company changed very recently, at the end of the fiscal, they changed the commission structure. So instead of earning this much percentage for these types of products, the percentages were all changed, the products were changed, the margins were changed. It was a big change. Well, the problem for that was, he said that now, as a result of these changes, I'm going to make less money. And I said, well, let's see, first of all, if that's the case. So when I first spoke with him, I told him, let's try it for a month or two. Let's see how this actually impacts you. Maybe you're wrong. Maybe it's not really going to impact your compensation. Well, after 60 days, he calls me and said, I've got my first two checks. I'm making 35%, almost 40% less than what I was making before. So I said to him, no, that is a constructive dismissal. You cannot have that happen to you. Your employer changed the terms of employment, changed the way you earn your income, in this case, compensation or commission structure. So he now doesn't have to accept that. He can treat his employment as being terminated and leave with his full severance. So remember, a constructive dismissal can happen in a number of ways. Anytime your terms of employment have been changed, it's a constructive dismissal, or absolutely can be. But the big one, kind of the holy grail, is you can't change someone's compensation. If the employer changes your compensation, maybe it's indirectly. Maybe they say from now on we're going to not give bonuses, or from now on you're not going to earn any more overtime. So your compensation even gets changed indirectly. That is a constructive dismissal. And it doesn't have to be a 40% reduction. Even a 5% or more reduction in pay can absolutely and easily result in a constructive dismissal. If you're ever in that situation, before you just continue working, before you be the good soldier and kind of take one for the team, you need to stand up for your rights. If you let your employer change your compensation one time, John, you may have given them the right to do it again. And the next time they do that, you may be stuck. Don't let that happen. Reach out to me.
You want to reach out? Simple, 1-855-821-5900, help@employmentlawyer.ca. For the people that are in sales possibly watching this today, and they're thinking, okay, I get my severance, say the calculator says I get 12 months severance or 8 months severance. Salespeople often have fluctuating paychecks. How do you calculate severance for salespeople? That aren't on a straight salary.
Right? Yeah. So if you're earning $60,000, we know what you're earning on every check.
Right.
But if your pay changes, sometimes it's more, sometimes it's less, it fluctuates. It's just as easy. We simply look at an average. Depending how long you work for the company, we may look at a 1 year or 2 or even a 3-year average and use that figure. So if on average you're making $60,000, some months it could be 30, some months it could be 100, but on average, if it's 60 as an example, we will use that figure. So that's also important for people that earn salary plus commissions. Many cases when the company pays severance, they'll try to calculate it just on the salary. That's wrong. All components of your compensation have to be included as part of your severance. Salary, bonus, benefits, commissions, car allowance, pension, you name it. It all has to be included.
We'll get to our first phone call, our live employment law show on radio. If you haven't caught that, you can do some searching and listen back to some old shows as well. But we take the good phone calls, not the good phone calls, but the interesting phone calls from that show. We play them.
They're all good.
They're all good. They're all good. If you've called in, my apologies. But we play them back in this show and we talk about them. First call for this show is right now.
I've been working for 23 years, and I'm the office manager, payroll, accounts payable, receivable, all that. And they're outsourcing, do it at another location. Within a couple of months, I won't have a job. And I was told that they wanted to keep me on part-time, but now it looks like they're just eliminating it completely. And I'm sort of on tenterhooks waiting to see what's going to happen.
How old are you currently?
66.
There you go.
Wow.
Yeah.
So she's been there for 23 years. She's 66 years old, and now she's worried about her job security. Well, there's good news and there's bad news. The bad news is that there's not much that she can do about avoiding this happening. If the company has decided to let her go or to outsource her position, it may be unfair. It may not be a nice thing to do.
Right.
It probably isn't. But legally speaking, they can do that. So even though, why should she lose her job? It's unfortunate, but they can do that. So she can avoid that. What she can do is absolutely make sure that when and if this happens, she gets everything that she's owed. She doesn't need to do anything right now. She doesn't need to proactively deal with this. At some point, the company is going to let her go that she doesn't have a job. If that's the case, at that time, they have to pay her full severance. I can tell you that given her age and then the fact that she's been there for 23 years, she'll be looking at 2 years' pay. 2 years' pay is what she's going to be owed here. So if you're ever in that situation, you know that the axe is going to fall, you're going to lose your job. Continue working, do your job to the best of your ability. There's nothing that you need to do preemptively. But when that axe does fall, when you do lose your job, when you're handed that severance letter, that's when you go into action. That's when you have to make sure that you get what you're owed, because most people don't. Most people are offered a lot less because the company hopes that they won't know any better.
Right.
So, no, you get your severance, and in this situation, she should wait, get her severance for her 2 years' pay, John.
It's smart not to wallow in the reason why you got let go or feel shame about it. Just worry about the back end. Worry about this on the back end.
And most people take a lot of pride in their job, and they don't want to lose their job. They work hard. There's a sense of accomplishment, a sense of identity that comes with your job. But again, from a legal standpoint, and sometimes the law can be fairly cold, from a legal standpoint, your employer can let you go even if you've done nothing wrong, even if you worked your butt off for all these years. They can let you go. It comes down to severance. That's why we focus on severance here on this show, because from a legal standpoint, that is what matters. Not the reason, not whether the company is doing it right or whether they have a good reason to let you go. It's what are you paid and how much severance do you get?
Part of the show that we do here each week is making, navigating your work life simpler. And we do that. Another great way is the Pocket Employment Lawyer, pocketemploymentlawyer.ca. Give them some details on it, Phil.
So I'm an employment lawyer. I answer questions all the time, but I know there's so many people out there still that have questions that maybe are hesitating. They don't know if they should call. Maybe they're like, I don't know if I want to talk to a lawyer. Well, don't worry about it. Before you even call a lawyer, you can go to a tool that I just created, pocketemploymentlawyer.ca. I'll say it again, it's pocketemploymentlawyer.ca. It's a tool that allows you to get specific advice for your situation. We've used technology to make this happen. So whether to find out if you've been constructively dismissed, we've talked about that on the show, whether the company had just cause to let you go, how much severance do you get if you are an employee or an independent contractor, if you've had your human rights violated, if you've been a victim of discrimination. All those things you can find out specifically. You go to pocketemploymentlawyer.ca, you answer some questions, and it's going to tell you, yes, you've been constructively dismissed. No, you haven't. Yes, you've been discriminated against. No, you haven't. There's cause. There isn't. Check it out. It's free. It's 100% free. I believe in people having access to information. So I'd be talking from both sides of my mouth if I said I'm going to charge you for it. So pocketemploymentlawyer.ca is free. It's anonymous. You don't have to put in your information or the company's information. You have that knowledge now. It's right there in your hand. Check out pocketemploymentlawyer.ca. And if you want to give me some feedback, I'd love to hear from it.
Again, you said free, you said anonymous, all these good things. That sounds very familiar. You'll remember severancepaycalculator.com. And that's nicely embedded right inside pocketemploymentlawyer.ca if you want to check it out or if you ever need it at any time. I want to get to an example here as we go in and kind of switch focus to say the severance pay calculator. Lior, as follows, 61-year-old Nick worked for a computer manufacturing firm for the past 28 years, most recently in a supervisor role. He was let go on Friday Friday, HR told him that he is owed 26 weeks severance pay. So do that max, by the way, that is the max, and that he has 3 days to accept the offer. Is he owed more?
So this is
Hurry up, though. He's only got 3 days.
I'll talk fast, John. No worries. So this is actually a true story. The only thing we've changed in this scenario is the name.
Yep.
That's it. Everything else here is factual. And we picked this not because it's unusual. We picked this one because it's so common. I get these types of scenarios, these types of calls or emails several times a day, every single day, and weekends as well. So let's break this down. So he's been there for all these years. He's owed a lot more than 26 weeks pay. And if there's a misconception that only certain people get severance, all that is wrong. So let's take his information. Let's plug that into severancepaycalculator.com. You can also reach it through EMPLOYMENT LAWYER.ca. And let's see how much our friend Nick is actually owed. So we know that Nick is a supervisor. He's been there for 28 years. That's a long time, 61 years old. And company says 26 weeks is all you get, and you better sign this within 3 days. Except Nick went to severancepaycalculator.com or pocketemploymentlawyer.ca and found out, well, wait a second, you can see that on the screen, 24 months pay is what I'm owed. Forget about 26 weeks. 24 months pay. Depending on his compensation level, that can easily be a 6-figure difference. So that's why it's so important to go to pocketemploymentlawyer.ca to find out your rights, especially if you lost your job. Do not accept less. Do not believe your employer telling you that you're only owed this much. And the worst thing you could ever do is be concerned about that deadline. It's a pressure tactic. It's all it is. It's there to make you feel like you have something to lose. So you have my permission. I'm on TV now, so I can't deny this. I'm on TV saying you can ignore that deadline. Instead, get advice. Go to pocketemploymentlawyer.ca. Don't sign before you do.
You've got 2 years. Right?
You have
got 2 years.
His legal rights, not only do they not expire in 3 days, they don't expire for a full 2 years. Now, I'm not saying wait 2 years. In fact, I think that would be a bad idea to wait 2 years. But if you need 4, 5, 6, 10 days to get advice, to get your head on straight, please do that. Do not worry about that deadline.
Again, pocketemploymentlawyer.ca is where you find that information, and right at the top is the severance pay calculator as well. Everything you need to know about medical leaves, we mentioned that off the top of the show. We will get to that after a short break. It is on the way right here in the Employment Law Show. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back to the Employment Law Show. We always take a topic each week and dissect it, get into some key points, and whittle down to the good stuff. So we're going to do that right now. Lior, this week it is everything you need to know about medical leaves. A lot of people wondering about this. A lot of people are on medical leaves as well, short and long, right?
And it's always an uncomfortable situation for someone when they have to go on a medical leave. They're worried about their job. They're worried about security. What happens when I'm ready to come back to work? What happens if I'm coming back to work and I'm not 100% healthy? So we want to talk about all those things so that you know what is your rights if you can't work. If something's intervened, an accident, an injury, a medical condition, then now takes you out of work. Because guess what, John? The law is quite good there. There's a lot of protections. So we want to explain what those are.
First point is this. How long can someone actually be away from work for a medical reason?
So there's no time limit. You can be off work as long as you need to, so long as you have a doctor backing you up, corroborating that you cannot work. So in some situations, hey, it's not a big deal. Maybe I had day surgery. I'll be gone for a couple of days, and then I'm back to work. Great. In other situations, it could be extended. It could be days, weeks, months, even longer than that. And you are allowed to be off work. You have not lost your job. You have not been considered to be let go or resigned or terminated. You continue to be an employee. You can be off work as long as you need to. You need to have that doctor's note. If a doctor says you cannot work, that's it. You then get that time off for as long as you need.
If I take this from the angle of an employer, am I allowed to ask for medical information about the employee that's off, like diagnosis, stuff like that?
An employer is allowed to ask certain questions. An employer is allowed to find out, essentially, when is this person going to be able to come back to work? Or do we have any information and an update on that? So they can ask, when are you going to get an update, or when are you able to come back to work? They can also ask, did you have any limitations, or can you do the job without limitations? We call that prognosis. So your employer can ask for prognosis. What they cannot do, they cannot ask information about your diagnosis. What is the condition? What treatment you're getting? What medication are you on? None of that are they allowed to know. Why? Because that's private. That's personal, and it's irrelevant. Whether you're suffering from a herniated disc or you have anxiety and depression, it doesn't change the fact that you cannot work. What matters is, can you work, can you not work? And if your employer asks you for that personal information, you absolutely can, and you should say no. They cannot demand it. You cannot get punished in any way for refusing to provide that. So prognosis, okay. Diagnosis, absolutely not.
Talking about all the important points you need to know about medical leaves, this one is another big one as well. What happens to an employee's job while they're on the medical leave, and should they, or do they have to update their boss or their employer as they're off? As updates?
So you remain employed. You still are an employee while you're on a medical leave, even if it's a long medical leave. Not only that, John, your time on a medical leave counts towards your seniority. So if you work for a company for 3 years and now you've been off for the last year on a medical leave, you're now a 4-year employee. So that time counts. So at some point down the road, if you are let go and you get severance, full time is gonna count. It's always a good idea to stay to keep your employment updated or stay in touch with your employer while you're on medical leave. You don't want to forget about your employer, and you don't want your employer to forget about you. So every once in a while, if you're on a long medical leave, send a note telling them, I'm working on getting better, send an email, maybe provide an updated doctor's note. That helps preserve your rights so that your employer can't say, oh, I assumed you weren't coming back. Always a good idea to stay in touch with your employer.
What does an employee do if they're not approved for disability or LTD, long-term disability, or in that matter, their claim is cut off while they're on one?
So a lot of employers provide long-term disability plan or a short-term disability plan for their employees, and it's there to compensate the employee while they cannot work. Well, unfortunately, many employees are going to find themselves in a situation where the insurance company either doesn't approve them or cuts them off the disability coverage before they're ready to come back to work. Well, unfortunately, this is done to frustrate the individual. Insurance companies often hope that by cutting you off, you'll give up, you won't apply, then they'll save a lot of money. Well, that's wrong. That's illegal. So if your employer or your insurance company cuts you off disability coverage, give us a call. We have a whole team at the law firm dealing just with this. We can deal with that insurance company. It's not that difficult. And of course, remember, even if you have been cut off disability, it does not mean that your employer can demand that you come back to work. As long as you have a doctor's note saying you cannot work, that's it. Your employer cannot give you a hard time, cannot doubt you, question you, ask for another opinion. You can be off as long as you need to be.
When an employee is ready to come back to work, what do they have to do after medical leave?
So we talked about the fact that the medical leave starts with a doctor's note.
Right.
Well, it also ends with the doctor's note. So if you're ready to come back to work, ideally you want to have a doctor's note clearing you to come back to work, saying, yes, this person can go back to work, and you provide that to your employer. And if your employer refuses to allow that, that could be a huge problem for the employer. The other thing we want the doctor's note to say is to outline if you need any accommodation. Maybe you need modified duties or modified hours because the employer has to accommodate. So give that note to the employer, telling them that you can come back to work, what limitations you have, and that switches the obligation on the employer to make all reasonable efforts to take you back and to accommodate you.
Well, you did mention it there, and that's the last point. What if you want to come back or you're ready to come back and the employer says, you know what, either your job is vaporized or no, I don't want to take you back. I got someone else.
Well, an employer has to make all reasonable efforts to take you back. In some situations, that's not possible. If it isn't possible, then you're owed your severance. But remember, your employer cannot simply say, well, you've been gone too long, we don't even want to talk to you. That is a human rights violation, not to mention potentially a wrongful dismissal. They have to make all reasonable efforts to look for a job. Even if your job doesn't exist, they have to see if they can find something similar. It's only once they've gone through that exercise and there's nothing legitimately there, then they can consider terminating you, but with your full severance.
I want to bounce over to another phone call from our live employment law show, radio show. So we'll get to that phone call number 2 for today.
Working as a courier, as an independent contractor, and what happened was I ended up getting fired for just telling other drivers that he wasn't paying us our gas allowance. And I wonder if that's the cause or if it's termination compensation.
Were you working full-time hours?
Yeah, strictly for him. About a year and a half.
And how old are you?
46.
Yeah. Well, John, this is a very common misclassification situation. He's working full-time hours for one company for a year and a half. What do we call that, John?
We call that wrong. And
we call that employment.
Exactly.
He's an employee.
He's not a contractor.
It's not a contractor. And this is such a common situation. He says he's a courier. I've seen this so many times with couriers, but I've seen it with truck drivers, hairstylists, IT professionals, with so many people that they're misclassified. He is an employee, okay? As simple as that. Now, by the way, PocketEmploymentLawyer.ca would have allowed him to find out in his specific situation whether he's really an employee or a contractor. You should check it out for yourself. So we know he's an employee. He's been misclassified, very common, which means he's owed severance. So let's go to our friend, the PocketEmploymentLawyer.ca, which calculates severance, and let's see how much he's actually owed. So we know he's a courier. He's been there for a year and a half. He said he's 46 years old. Because he's an employee, because he's not an independent contractor, he's easily owed 3 months severance, 3 months pay. So if this is a very common situation, it may be your situation. You're watching us right now thinking, wait a second, are you telling me I'm not really an independent contractor? Yeah, that's exactly what I'm saying. You are probably an employee. If you lost that job of yours, you're going to be owed severance like an employee. Don't believe me? Go to PocketEmploymentLawyer.ca and check it out for yourself.
Because a lot of employees are going to say, well, I agreed with my employer. We both signed a contract saying I'm an independent contractor. That must hold water.
It doesn't.
Right.
It really, the reality on the ground is all that matters. You can sign a piece of paper saying that you're the prime minister of Russia. That doesn't make you that, right? It's the same thing. If you look like an employee and you act like an employee, you are an employee, even if you signed a piece of paper that says something else. Doesn't matter how you pay your taxes, doesn't matter even if you have your own incorporated company, the law may absolutely still consider you to be an employee.
Coming up here, the legalities after being fired for a customer complaint. That is on the way. Stick around for it here on the Employment Law Show.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.
And welcome back to the Employment Law Show. John Scholes, Lior Samfiru. We take a ton of phone calls from our live radio show, the Employment Law Show on radio. We like to get to them and dissect them because we do it all show long on radio, but it's good to nail down on a couple specific ones that bring some points to the viewer and let them know what's going on. So this is call number 3, I think, for today's show, pal.
I was recently temporarily laid off, and I was just wondering if they gave me a 13-week period, and I was wondering if I'm able to ask them for severance.
How long have you worked for the company?
7 years.
The old temporary layoff.
We've talked about this before on the show, and I still get calls like that all the time. So let's make it very clear that a temporary layoff is actually illegal in most cases. By illegal, what I mean is the employer doesn't have a right to lay you off temporarily. They don't. And if they lay you off temporarily, you have a choice. You can accept that layoff and sit at home, and if they call you back, go back. Or you can treat that as a termination right now and get your severance. Not 13 weeks from now, not 35 weeks from now, now. So that's what I told this person when she called us on the radio. No, you don't have to accept this. You can treat that as a termination now. So the question is, how much severance is she owed? Well, let's again go to pocketemploymentlawyer.ca or same as severancepaycalculator.com, and let's plug her information in to see what she'd be owed. So I assume let's take a position. Let's say she's in sales, 7 years of employment. We know. Let's assume she's in her 50s. She was offered no severance because her employer said she's quote unquote on a temporary layoff. Right. Except, John, severancepaycalculator.com. You see that on the screen. Says she's owed 8 months' pay. 8 months' pay. That's how easy it is to use. And remember, when it comes to temporary layoffs, they're illegal. Your employer does not have a right, unless, of course, you've given them the right to do it by allowing it to happen before. That's why if you've been laid off temporarily, don't let that happen. Don't accept it and stay home, because guess what? If you do that and you end up coming back to work, the company can do it again and again and again, and then you're stuck.
You know, it's funny when we talk about temporary layoffs in the show, and you've made this comparison saying, you know, if you walked up to the same employee and said, you know, how about I dock your pay by 50% for 13 weeks? No, get out of town. Well, how about I take 100% of your pay for 13 weeks? That's what a layoff is.
That is exactly what a temporary layoff is. Right. That's why it's illegal. There's no right like that. Just like you couldn't tell your employer, I decided for the next 13 weeks you pay me double.
I'm in.
Well, if you can't do that, your employer can't reduce your pay to zero for 13 weeks or for 8 weeks or for any other period of time. Yeah. It's a termination.
TerminationQuestions.com. That's a resource for you to ask questions, and Lior and his team answer them and give you the information you're looking for. Here's the first one for the show today. It says, I was dismissed from my job of 4 years after one single customer complaint. One single customer complaint. This was the first complaint I've ever been aware of, and there are no complaints on my employee file. Were they legally allowed to fire me?
So obviously, you know, an employer should expect good performance from its employees, and you know, if you do a good job, hopefully there's no complaints. So let's look at it from the employer's best case scenario, that this employee made a mistake, it was some sort of an error, and they got a legitimate complaint. But that's not the real issue. The real issue is that, even if it happened, is it bad enough to allow the employer to let them go for cause? John, it's not even close. The fact that this person may have done something wrong, maybe they did, maybe they didn't. But even if they did, it does not mean that it rises to the level of cause. It's so difficult to terminate someone's employment for cause. It's reserved for the worst offenders, So now, if this person had several customer complaints, she was warned and she didn't get better, she was warned again, well, at some point, that employer may say, well, there's nothing else I can do with you. I'm going to let you go for cause. But if this is a one-time thing or a first complaint, she cannot be let go for cause. That would be a wrongful dismissal. Mm-hmm. The flip side of that, though, John, is her employer is allowed to let her go, but they'd have to pay full severance. Right. So even though, as I said, it's not that bad if there's one complaint, if her employer still wants her gone, they would have to pay her full severance. Otherwise, it's a wrongful dismissal.
They would have to build up wrongdoings before they can let her go, right?
Yes, it's not easy to let someone go for cause. So if you want to, as the employer, you have to put in the work. You have to build up that case. You have to have warnings. You have to have potentially a suspension on record. You have to show that you've tried to do something other than just terminate someone for cause. In my experience, most employers jump the gun. They say, you did something wrong, therefore it's cause. It's not. One does not equate to the other, and if your employer jumps the gun like most do, that's a wrongful dismissal. You could be owed significant compensation. You have to reach out to me.
Good way to wrap it up for another show. Again, if you haven't checked it out yet, pocketemploymentlawyer.ca. Through that, you can access a severance pay calculator. 1-855-821-5900 is the phone number, and quite simply, employmentlawyer.ca to reach out as well. Thank you so much for joining us. We'll see you next time right here on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.